Good morning, everyone. My name is Nancy Gertner. I am the moderator of Winner Stays, Loser Pays Developments in Fee Shifting, and we welcome everyone here. Everyone's bios are in the materials, but I'll give a brief introduction. Here's the way we will do this. I will give a brief introduction. We then have, if you've been to any of these other panels, you know the way it works. Each individual will just sort of do a 5-minute précis of what they wish to talk about, and then we'll open it up to questions amongst the panel members, and then we'll open it up to questions in the audience. Everyone is to shut off their cell phones. We're told that there's the timekeeping will be done by in a sort of fascistic style, I might add. With respect to questions, you have to wait for the microphone to get to you so that the questions can be short and actual questions. There is a networking lunch that's going to begin immediately following this panel in the presidential ballroom, followed by the closing plenary. So we are supposed to end on time. And this is a panel for CLE credit. And I'm supposed to remind everyone of that. That concludes my Miranda warnings. So, as I said, I'm Nancy Gertner. To my left is Adam Klein, who's a partner in, I can't pronounce it, Outen and Golden, who is the chair of the firm's class action group. His practice is limited to the prosecution of class action and impact litigation of employment discrimination and wage and hour claims. Next to him is Patty Goldman, who's vice president for litigation and Earth Justice. She leads the organization's litigation and oversees its 9 regional offices and its international program. Next to her is John Bowman, who's the director of Federal and State Relations, American Association for Justice, formerly the Association of Trial Lawyers of America. He manages AAJ's advocacy efforts on transportation, technology issues, insurance reform, and my personal favorite, federal judicial selection. And finally, Harry Sussman, who's a partner in Sussman and Godfrey. His practice focuses on complex commercial litigation, including securities fraud, antitrust, and patent litigation. While he represents both sides, he says, his practice focuses on plaintiffs' contingent fee cases. So I just want to frame the discussion briefly. The United States stood alone among major industrial countries, notably Canada, Australia, in having in rejecting a loser pay system. In the United States, each side would pay its own costs and fees, rather than a system in which the losing party paid costs and fees. There were always an exception in the event that a lawsuit was brought that was patently frivolous. A judge always had the discretion to award fees in a patently frivolous case, but that was really the exception and not the rule. The rule was everybody pay their own fees. With the advent of civil rights statutes, Title VII notably, 1983, statutory provisions for attorney's fees to the prevailing party began to proliferate. This was not an aberration in the United States. It was a choice to some degree. It was a choice to have the concept of a private attorneys general who would litigate in the public interest, employment discrimination, environmental issues, immigration issues, civil rights cases, litigate in the public interest, and should they win, get attorney's fees for what they did. We did this in lieu of an enforcement structure that would be a government enforcement structure, where there would be the government office of enforcement that would deal with private civil rights issues, environmental issues, et cetera. Not in lieu of, but in addition to. But we clearly made the choice that this would be a way in which we would enforce civil rights. So the movement away from attorney's fees for prevailing parties to one in which a plaintiff in a civil rights case or an environmental case, if they lose, it's one thing to say their lawyer doesn't have to be paid as they would if they were the prevailing party. It's quite another thing to say that the loser, poor people, plaintiffs in these cases, have to pay. So it's a substantial development put in the context of issues that have been discussed in the rest of this conference put in the context of more stingy attorney's fees awards, more limitations on when attorney's fees award are available, even in cases in which the plaintiff is the prevailing party, put in the context of limitations on litigation in a whole host of situations. This kind of litigation makes this a really serious development. Our panelists will deal with this from the perspective of either statutory, those who get statutory attorney's fees, as well as we'll also talk about two states in particular, Texas and Alaska, that have enacted loser pay statutes. The rationale on the other side is that it somehow limits litigation, that somehow fewer cases will be brought. The concern on the other side is that the cases that will be stopped or chilled will be civil rights cases, environmental cases. So with that, I want to begin with Adam, who will talk about whatever he wants to talk about, but is supposed to be talking about. We're going to begin, with Harry, who's going to talk about the impact of fee-shifting legislation in Texas. But everyone's going to talk about whatever they want to talk about, which is clear.
I will talk about whatever I want to talk
right.
about. But good morning. I'm going to talk about the two ways in which I run into this loser pays or will in my practice. The first is in Texas, where I'm from, where we enacted loser pays, sort of. It was enacted in 2011. Rick Perry wanted to run for president, and so this was kind of one of his things, was to enact loser pays. But it was done in a very modified fashion. And in Texas, of course, we already had massive amounts of tort reform. And this was just part of that effort. As I said to John at the beginning, I mean, enacting loser pays after what has happened in the previous 20 years is really like desecrating a corpse to then go ahead and do this. But what ended up emerging really isn't a huge issue because how it works in Texas, to summarize very quickly, it only applies to a motion to dismiss. If a party files a motion to dismiss, which we didn't have in Texas before this, then whoever, if the defendant wins, obviously the plaintiff has to pay, and if the defendant takes a shot and misses, they have to pay the plaintiff's fees defending the motion to dismiss. But an additional feature or two features about it that's worth noting. One is that the standard to get dismissal is very high. It's probably a lot higher than what's in the federal rules. Or by the federal case law. So it's, the deck is stacked in favor of the plaintiff to a certain extent, which is going to be a huge deterrent effect, I assume, for defendants in filing these motions. And there's a strict time limit. The motion's got to be filed like within 45 days of the pleading, and it's got to be decided by the court like another 45 days later. With the impact of that is that the attorney's fees that you can generate during that time period are relatively modest, obviously. So given that, my understanding from what the defense lawyers are being taught in-house is that they should not even invoke this procedure. That judges will be very reluctant to grant a motion to dismiss. The standard's really high, and they're not going to want to stick somebody with attorney's fees, the plaintiffs. And so defendants run a big risk of getting stuck with the plaintiff's attorney's fees. And so why do it? There are other ways to get a case dismissed. And I suspect that that's probably what's going to happen. The law, although it passed in 2011, just became effective a couple of months ago. But I haven't seen very many of these motions to dismiss get filed. You also, of course, you can, just like Rule 11, you can withdraw the pleading in response, and that removes the risk. Now, I will say one thing about it that may be worth noting is that when you think about loser pays on a more general scale, the idea of confining it to a motion to dismiss has some appeal in a certain way in that, obviously you would hope you'd get a resolution early in a case so that the plaintiff or defendant, there's not as much of a risk to either side. And presumably it would impact only cases that were really losers, and obviously so based on the pleadings. But it'd be somewhat problematic in the federal system where, you have It may work in Texas where the motion to dismiss has to be decided in this 90-day window. In a federal court, my God, you have a motion to dismiss that, is pending while the case plugs along. And so you can have very large fees. So that's one area. And then the other thing, and I'm going to let John talk more about this as well, we do a bunch of patent litigation in my firm. And, the big issue now is to try to stamp out what are called, patent trolls, non-practicing entities. Entities that hold patents that do not produce any goods and simply are in the business of litigating and enforcing those patents. And there has been a proposal last year, there's one now called the SHIELD Act, which would provide for loser pays only for non-practicing entities. And only in those cases, there's like a procedure that's set up where you would determine whether someone is a non-practicing entity, and we can talk about what that really means. And then if you are deemed to be a non-practicing entity under this proposed statute, you'd have to post a bond in the amount of the potential attorney's fees at issue. And then, if you lost, you'd have to pay the other side's fees. And with that, I will
Okay, that was
turn that over to
exactly
John.
what I was going to talk about. He's talking about Bill H.R. 845, called the Saving High-Tech Innovators from Egregious Legal Disputes Act. Yeah, I thought you'd get a kick out of that. This bill was initially filed by Mr. Peter DeFazio of Oregon, who is, by all means, a pretty liberal Democrat. He filed it last year, and it was very narrow. It only dealt with technology, only computers and software. He has a firm in his district that was trolled, and no one is denying that that is a legitimate problem. There are people who buy older patents and then try and exploit those patents because now the technology is widely available, has been used by so many different people. It may slightly resemble what it began 14, 15 years ago, but the patent is for 17 to 20 years. So these people have technically legal, legitimate claims. Really, they're kind of slimy. So no one is denying that there isn't a problem. The way that they're trying to go about fixing it, and I think one of the big problems, and it's been a problem for a while in this area, is how do you define non-practicing entity? How do you basically just get to the patent acquiring entity, who are those people who simply just go out, acquire patents for the sake of suing people and alleging infringement? And those folks, we don't count us at all. We think they should be dealt with. Unfortunately, no one has really come up with a reliable way to fix that. And I don't want to just delve up into a discussion of patents. If that's where you want to go, we can do that later. But we hadn't really seen loser pays proposed in Congress since Newt Gingrich's Contract on America. And
Contract for America.
Okay.
Okay.
if you say so.
Right.
And that was, clearly passed the House on a party line vote. In the 90s, the Clinton administration threatened to veto it. It never passed the Senate. So it never became law. We did see, and this was on the heels of sort of a failed experiment in Florida. In 1980, the Florida Medical Association, the American Medical Association, all the insurers decided that, we've been trying to get loser pays for years. We've actually got an opportunity to do it now. And so they passed it. They passed it into law, and lo and behold, a couple of plaintiffs' lawyers won really big verdicts against doctors. And the way plaintiffs' law works is generally you get a portion of the recovery, usually about 30%, sometimes 40% if it goes to appeals. So instead of taking the 30% out of what was recovered from a few of these doctors now had to pony up an additional 30 to 40% on top of the recovery. All of a sudden, this didn't seem like a very good idea. So in 1985, with both sides cheering it on, it was repealed overwhelmingly. So after the fact analysis revealed that it probably did result in a few cases, about 10% more cases being dropped because of the rule, but it clearly was something that both sides didn't want to risk. The jeopardy, I think, was too high. We do have one state that has had loser pays in some form for its entirety, and that's Alaska. Alaska has loser pays in virtually every aspect of the law. It goes both ways. The maximum amount of cost that you can get is 30%. Generally, it's 20% of the first $25,000 and then about 10% of everything else. It hasn't really changed the way plaintiffs' lawyers practice, my folks tell me. It affects a narrow group of people. Well, it affects two groups of people, one more than other. The narrow group is middle-class folks with some assets and something that they can lose. People with higher incomes who don't mind taking the risk, they really don't care. Poor people, they don't care because they're judgment-proof. So even if they lose, there is nothing that any defendant company can really go after and get from them. So now we're here with the SHIELD Act offered by Mr. DeFazio. I can tell you I've had a couple of very heated exchanges with him. He gets that this might not be the way to go, but he says loser pays has to be a part of the equation. And it'll be interesting to see how it plays itself out.
Okay, Patty?
So, is this on? So I want to give you a flavor of how fee shifting has worked in the environmental arena and basic administrative law. And here we're talking about private attorney general and one-way fee shifting under the statutes. So to give you a flavor of the role, I want to take you back before the first Earth Day, where we didn't have citizen suits. What we had is people being able to go to court when they were injured, when they had damages to their property, personal injury, and basically seek remedies after the fact, damages after the fact, rarely prevention. And then we got our alphabet soup of different agencies and laws, the Clean Air Act, Clean Water Act, Endangered Species Act, toxics laws, and in many of those, Congress added a citizen suit provision, modeled in some ways after the civil rights statutes. And here's how it works. An individual who is harmed by the pollution, maybe living near a polluting facility, or who uses a body of water to fish, to go boating, they have the interest in that area, and they then will know the damage that's being done and have the incentive to go enforce. And they can file a notice of violations with the wrongdoer, the polluter, and say, I'm going to sue you if you don't clean up this pollution and stop this violation. The government can overfile and bring that case and prosecute, but if it doesn't, the citizen can do the prosecution. Even if the government does, the citizen can come in and help. And most of these cases are done by citizens, not the government. The government doesn't have the resources or often the political will to do these cases. And so the citizen will go, bring this case, stop the pollution, maybe get a restoration remedy. There's nothing in it for the citizen. There's no money damages that go to this individual. It's basically doing a public good to stop the pollution. If there are penalties, which can be imposed by penalties of a certain amount per day or overall for the case, they go to the U.S. Treasury, not the individual. So the individual is doing a public good. And part of this is they get their fees when they prevail in the case, basically to reimburse them for doing this public good. So that's your basic citizen suit model. So I want to introduce one other concept and then tell you a bit of how they're both under attack. So the other is for basic administrative cases, cases brought by federal agencies. This is an extension of the fundamental principle of judicial review and holding our government accountable to the law. And with the whole development of the administrative state, this became very important, and in 1980, a piece was added, the Equal Access to Justice Act. And it provides that when an individual member of the public or an entity goes it brings a case to hold the government to the law, federal agency, to its delegated authority, to reasoned decision-making, and it wins, a court can award fees if the government's position was not substantially justified. I want to give you a couple of quotes that give you a flavor for this from the legislative history. And keep in mind, this wasn't just environmental kinds of cases or impact cases. This was people seeking veterans benefits, Social Security, disability benefits, small businesses. So my favorite two quotes, one from Senator Grassley, and he said in 1980 that the citizen, the individual, faces a Hobson's choice, either to fight unjustified government enforcement or regulatory actions at great personal or financial cost, or to capitulate in the face of meritorious action. My second favorite quote from Senator Heflin in 1985, when the act was reauthorized, said that this statute serves as a deterrent to arbitrary government action, a basic good government statute. So, The attacks. So first on citizen suits, what we have basically is judicial interpretation starting in 2001 with the Buchanan case in the context of civil rights statutes that said that a plaintiff who prevails can't get the fees if the action catalyzed the change, called the catalyst theory. Previously, a party prevailed if the action caused the wrongdoer to change their actions. You catalyze the change. Now, under that decision written by Justice Scalia, there must be a change in the legal status, a judgment or a consent decree on the merits that changes the legal relationship between the parties. An incentive not to settle, jack up the fees some more if you eventually win, and that is being applied by the various courts to different statutes. If they have prevailing party, you tend to get that rule. If the statute says the court can award fees as appropriate, you tend not to get that rule. The other attack comes from Congress, and this is on the Equal Access to Justice Act, called the Government Litigation Savings Act. There have actually been many different bills that try to cut back on fees, and there are various concepts here. Some would be capping the amount of fees for an entity over a period of a year or the number of cases. Under the Equal Access to Justice Act, nonprofit organizations are eligible. There would be a net worth cap for a nonprofit. Query, I love saying that in legal audiences, what does that mean for a nonprofit? But my favorite is, well, originally, let me just say that the act attacked all claimants, and then it actually helped put together a wonderful, robust coalition of all of the entities, the veterans groups, the disability groups. But then the target became impact litigation, and they did it by saying a plaintiff could be eligible for fees only if it has a direct and personal monetary interest that would be in the form of personal injury, property damage, or an unpaid benefit from the government. And this resonates particularly with me. My organization has its origins in Sierra Club versus Morton, the case that established that you can have standing to get into the court, not just having a personal injury or property damage, but because you have an aesthetic interest. You care about the environment. You breathe the air. You use the river. You're a bird watcher. You want birds to still exist. And what this is doing is a throwback to before that stage. And you may think this is an attack on attorneys and attorneys' fees, but it's really an attack on the underlying right to get into court to protect these values. And that's what at stake. We're an easy mark. We're the ones that are easy to attack, those greedy lawyers. But it's really an attack on the ability to perfect these rights. They stay on the book, but we won't be able to enforce them.
Can you make us happy? Harry. Just wanted, can you cheer us up?
Well, I don't know about that. Sorry. So, so let me just give you a very brief background, and then I'll sort of describe the impact here. So I'm a plaintiff side employment lawyer. I only prosecute class actions, and I think consider myself a self-professed, wide-eyed liberal, perhaps radical lawyer at this point in 2013. And let me just describe sort of the absurdity and perverseness of this idea of, shifting fees and costs onto plaintiffs in the event that the plaintiffs do not prevail. So an illustration of the problem and the absurdity of it. Right now, we're prosecuting, I think, the largest Title VII class action in the federal judiciary. It's against the United States government. It involves about 400,000 applicants to the 2010 decennial census hiring process. And our claim is that the Census Bureau used criminal history records as an impermissible screen for employment, which violates Title VII under disparate impact grounds. Each individual client, and in fact the named plaintiffs themselves, economic interests are tiny in relation to the aggregate exposure to the government and notably to the costs and fees that are generated on both sides. So there's an obvious asymmetry in terms of the risks that are borne relative to the potential recovery of any one individual plaintiff. So, if you had a rational conversation where there was some reasonable prospect that my couple of named plaintiffs would have to pay the United States of America, the Justice Department, their fees and costs, and you sat them down in a room and say, okay, let me explain this to you. If we prevail, you'll get maybe $5,000 or $10,000, and we'll wish you well, and that's your recovery, and thank you for doing it. On the other hand, if you lose, the United States of America will send you a bill for $40 million. I'm not kidding. That would be what the result would be. What would you like to do, plaintiff? Now, there are a couple obvious answers to that. One, they would immediately file for bankruptcy, and so who cares anyway. And two, it's sort of a goofy idea that the government or any defendant would chase after a particular individual when the amounts at stake for the plaintiff were maybe, reinstatement to a job or economic loss with respect to their individual claims of discrimination versus the legal fees and costs that are generated in the litigation. In 1978, by the way, under Title VII, there's a Supreme Court decision, EOC v. Christenberg Garment, that laid out sort of the conceptual framework for when it's possible for a defendant to recover fees and costs from the plaintiff. And essentially, it's frivolous, unreasonable, or groundless litigation that would be the predicate facts to support a fee shift back to the plaintiffs. And ironically, most of the cases that address this issue under Title VII relate to lawsuits against the EOC. So it's the EOC versus somebody, and somebody says, government, you brought a frivolous, unreasonable, groundless case, and we're gonna recover fees. Now, there's an obvious reason why that happens, or maybe two. One, the government has an interest in bringing more cutting-edge cases, law reform cases, and cases involving, issues that are uniquely within the ambit of what a government agency should be litigating, whereas the private bar probably wouldn't want to take those cases. And two, there's money there, right? There's money and then there are hills. The government has money and you can recover something, whereas if you chase a plaintiff for millions of dollars, with rare exception, the fact is either the person simply won't pay or file for bankruptcy. So it's sort of a meaningless gesture. I think it's also obvious that if you were to change the standard, if you were to use the UK rule or non-American rule, loser pays dynamic, it's obvious sort of what happens then. It would completely eliminate any kind of law reform type of case. So my census case is a great illustration. The case is about changing the way that the government engages its workforce on a very fundamental level. Can you use criminal history records? What are the constraints? That's not a case about money necessarily, although there's a money component to it. It's more a case about the government violated Title VII and somebody should stand up to it. And by the way, there's no federal agency charged with enforcement against the federal government. This is the only way that case gets prosecuted is if private lawyers take it on. And so you wouldn't see that kind of case in the UK, for example. In the UK, and I have friends who are solicitors there who are employment lawyers, and what they'll say to you is, my concern is my client's individual issues and circumstances. I'm not interested in law reform. I'm not interested in the broader issues. And the reason is that there's a direct cost to my client if I'm wrong, if we're wrong. And it's sort of a deal or no deal situation where at each step of a case, you have to assess the relative risks of moving forward versus the potential that you will lose. And so there's this kind of Bayesian game theory dynamic that plays. And what happens is that there's tremendous incentives that are placed on the defendant to stall, dissemble, obstruct, not provide information, right? In other words, to the extent that in a Bayesian economic or game theory dynamic, you can affect the risk calculus by denying information, that increases the risk on the other player. And so if you think about it, there's tremendous incentives just based on a game theory dynamic to obstruct, to not be a fair player, to not provide information transparently. And so, that's exactly what's happened there. There are relatively few cases, and there are almost no law reform cases. No cases brought on behalf of a group or class group. And so I think you have an answer to what would happen here in the United States. It would essentially end, I think, private enforcement of Title VII if there was a loser pays provision. I don't think there's any question about that. The good news is I don't know that the Republicans are figured that out as a sort of a talking point at the moment. So there you have it.
It was not making us happy. Harry, you made an interesting distinction between the Texas law that triggers losers' fees, loser pays on a motion to dismiss, and you made a distinction between the standard that is in state court and the standard that is in federal court. Is there any pressure in Texas to change the motion to dismiss standard? In other words, if that were in federal court, in a world in which we're now dealing with motions to dismiss based on an Iqbal and Twomley standard, where the judge is authorized to look at whether the complaint is plausible, that would have a very different impact on this. Is there any pressure to change the motion to dismiss standard?
No, well, we didn't have motion to dismiss at all, so one of the things they did was they created this. And what happened was the legislature said, told the Supreme Court to enact a motion to dismiss for a case that had no basis in law or fact, I think is what the sentence was that the legislature had used. The problem is that that's the sanction standard.
Right.
And so the Rules Committee said, well, that can't be what they meant. So they tried to come up with something else. What it exactly means, no one really quite knows, right? But it appears to be a very high, standard. And it's not Iqbal or Twombly. That was also conscious. So the truth is that, as I say, this rule has only been in effect for 2 months now. So there's not really been any pressure, I think, there. But I think the point is that where you've got losers pay in a situation where the deck is already kind of stacked for one side, which it is in a motion to dismiss, it's ostensibly stacked in favor of the plaintiff, although in the federal system, question whether that's true. It impacts. I don't think you're getting a true read on the way loser pay works when you just implement it in that kind of narrow situation.
But it raises the question of you can't look at loser pay out of the context of civil litigation in general. Standards for motion to dismiss, standards for discovery. Do you get discovery while the motion is pending?
No.
I take it not.
None, yeah.
Okay. John, the Shield statute,
Hopefully it won't become a statute.
okay, the Shield
Proposal, right.
Shield proposal. Is there any chance of a spillover effect? I mean, could that become the model for other legislation?
That's certainly one of our advocacy points. We think it could. The loser pay aspects, which we're going to fight vigorously. But we have seen, as it relates to patents, there are probably 4 or 5 additional bills now, and all the ones offered by Republican members of Congress have a loser pay provision in it. There are 2 that Senator Schumer and one that Senator Leahy is about to propose that don't have those provisions. But yes, we are afraid that it could become a model.
Is there, you also talked about Alaska, and the question is whether, you said that the Alaska loser pay system doesn't affect affects the middle class because they have assets, doesn't affect poor people because they're judgment-proof, and doesn't affect the very rich because they already have the resources. So one argument against loser pays is that it will in fact stop important litigation. Does the experience in Alaska suggest that it's not stopping important litigation, or was there never important litigation in Alaska to begin with?
I don't know if
I don't mean to say that.
Yeah, I don't know if I can make that determination. I don't think it has, I don't think Alaska differs very much from other jurisdictions by folks who've tried to compare sort of apples to apples in terms of the actual plaintiff's case filings. Those people who are probably in the middle class are a little bit more hesitant. There was an example, and this isn't an Alaska example, it was an example in Canada of a professor who sold his house. And during the pendency of the sale before closing, the housing market basically bottomed out, and his house was worth substantially less than the agreed to selling price. And at the closing, the buyer stated that he would only pay what he thought the house was worth at that point. And the professor had 2 choices. He could either walk away from the sale, and he'd already bought another house, or he could accept it and then try to recover later. He did the latter, went to counsel, and because of loser pays, even if he were the prevailing party, if he got some money and it wasn't as much as what was different, he would have been subject to loser pays and could have been on the hook for about 3 times as much as he would have lost. So he decided not to go forward. I think that's an example of those people who have some assets and would lose if there's a case that's not, open and shut case.
On Alaska, that you might hear what John's saying, that it had that it's okay, it's acceptable. Or the Alaska experience is not really loser's pay either. It is riddled with exceptions as to when it applies. It's not very big percentages, so that it's kind of like the Texas thing. Just because, the fact that it has not, which apparently it hasn't, apparently it's really had no impact on filing of cases. Or very little. And so one might say from that, well, see, it works. right? I mean,
Right.
there's, people still file their cases. And I think that's the wrong lesson to draw from Alaska.
Can I speak to Alaska, too?
Yeah.
So the Alaska rule, the Alaska Constitution has a provision about access to the courts as part of due process. And based on that, the Supreme Court had read into the rule a public interest exception. And that was, so that kept the courts open to a lot of public interest kinds of cases. But then the legislature didn't like the environmental cases, and so they got rid of that exception in 2003. And we challenged that, along with others, saying that that would violate the right of access to the courts. And what the Alaska Supreme Court said is, well, the judge still has the equitable discretion to limit or not award fees. And so in a case where there might be a chill, then the court could apply that principle. So think about that for a minute. It's the ones that aren't chilled, so they go to court in the first place. So it's basically a wholesale retail problem. The wholesale system still says you could be on the hook for the fees. Retail, in the particular case, the judge could decide not to award
But
them.
you don't know that until you're in the midst of the litigation.
Precisely
So you
the
make
problem.
the calculus at the beginning.
Yeah, so you're still on the hook. So that, what that did is that dried up all of the public interest cases, except for one. There is still an exception for constitutional claims. So either a lot of the public interest cases would be presented as constitutional claims, or those would be the only kinds of claims pursued. So recently, there was a case brought by a series of environmental groups represented by a nonprofit environmental law firm on the Pebble Creek mine. You might have heard of that. And they were raising constitutional claims for lack of notice on some state permitting. They lost. So Alaska, the state, and the Pebble mine are going after them for fees, basically trying to say it's not a legitimate constitutional claim, or there's another provision that says if there's an economic interest that's fueling the case, then the loser pay rule applies. So they're trying to take discovery of the nonprofit organization, the nonprofit law firm, and the foundation that funded both of them to find out who are their donors. And did the donors have an economic interest? And therefore, this exception to the loser pays should not apply here. So we've filed in front of the court brief, so has the American Civil Liberties Union. The good news is, just this month, the Supreme Court, I guess last month, the Supreme Court took the case and asked some questions about what does economic incentive mean? And in this context, would the donor have to actually be able to control the litigation? And should there be some threshold showing before you can get discovery to try to probe who are the donors? What are their identities? How much did they give? What are their economic motivations? And did they control the case? So that's all the good news. But it's alive and well. And I can tell you there has been chill on public interest cases in the state of Alaska based on the cracking down of the public interest exception. It may not, I mean, maybe a little group might feel they don't have that much to lose, but I don't think the board of directors and the fiduciary responsibilities are actually going to take that risk. And so we actually have those discussions with clients. It does definitely chill.
This is along the lines, Harry, of what you were talking about, which is the extent to which, to the extent to which actually right and left might unite in some concerns about this, which is to say access to client, to who your donors are, who's in the, who's behind you on this. Is there any way of trying to oppose this by suggesting that it will chill challenges to rule rule challenges, and it will chill, it will get access to some of the rights donor lists as well? Is there any way to make that kind of argument?
Well, it's an interesting question. I mean, I don't know, I don't know exactly in the Title VII realm, which is sort of where I'm coming from, how this intersects with, with our interests yet. I mean, it's certainly, I suppose, possible that, one line of attack, and it's comparable, and maybe, and I'm just thinking out loud now, but it's comparable to the class waiver idea, that you can essentially, do away with, agree to do away with your rights to access to the court system. It amazes me, just on that point, it amazes me that, you see the right wing talk about the Second Amendment as sort of the sacred cow, and yet the Seventh Amendment right to a jury trial is gone as a practical matter, even where the agreement to waive the right to jury trial is in a click box that you hit, that is a contract of adhesion, where you have no right to negotiate, there's no consideration given. That you can waive. But God forbid somebody says you can't have, a bazooka, then that's protected by the Constitution. It's just this wacky kind of, I love the textualist concepts of, well, it's got to be in the Constitution and you can't change it. It's just nonsense. It's gibberish. Because when you turn around and say, well, wait a minute, if that makes sense, then how did we lose the right to a jury trial? Oh, well, that, don't look behind the curtain. And I think it's sort of the same construct here, which is, it's gobbledygook, but it's possible that they'll come and chase after us and make these same arguments.
Did you want to say something?
Well, no, I mean, I guess the main argument to the right as to why this loser pays is they obviously don't care about access to justice and that sort of thing. I mean, that's not going to motivate them. But, I mean, the argument is, of course, that if you have a loser pays system, you may, in fact, generate there's not a lot of good literature that say what would happen if you instituted a loser pays in the United States. We know in these other countries, they don't have litigation at all like ours, but is that because a loser pays, or is, their systems are totally different than ours in various ways, no contingent fees, so there's not really a good comparison. If you just made that change in the United States, would that deter the filing of litigation, which is the goal of the right wing in pushing these things? And it might, but an argument could be made that in fact it may generate a whole bunch of litigation over small claims because lawyers, this is kind of the argument against some, Title VII cases where, you've got somebody pushing a claim, it's lawyer driven. It's all about the attorney's fees. And that if in every case attorney's fees were available in every small consumer complaint case, a lawyer could get a hold of that, file the case, the damages are small, but I'm going for fees, right, because I got you on liability. And so, the argument could be made, look, if you support this, you're going to get hit with, a zillion of nuisance suits that are all about attorney's fees. And so that's the sort of way in which it can backfire on you.
And then also putting in the context of other issues, which is not only Iqbal Twombly, limitations on class actions. In other words, the notion that people go and file these suits without basis makes less and less sense in a situation in which now the civil litigation system has begun to contract. More substantial discovery rules, more substantial standards with respect to Iqbal and Twombly. So is the answer to the impact of loser pays, it depends? It depends on whether you're talking about an environmental issue in which you're really focusing on injunctive relief versus class action in which there may actually be money for the lawyer in some kind of theory. Is loser pays going to matter depending on the context? Or is it something that we ought to pose across the board?
Well, it's interesting because I think the position that I was presenting is one, and I think what Adam was as well, where we want the loser to pay when we are being private attorneys general and we are promoting public policies by enforcing the law, and we're a piece of the system, or we wouldn't have that enforcement. It's a one-way fee-shifting statute. Congress has decided this is in the public interest. What we're starting to see is the arguments the other way. Under those statutes, now you should pay our fees. It's coming up under the Clean Water Act, and we're seeing it in different state actions. And what I think is really troubling there is it's trying to collapse the fee-shifting statutes like the Clean Water Act and sanctions, and trying to get around some of the burden of proving an entitlement to sanctions. And when you were saying that the language was a groundless case, that's what they're trying to say is, oh, well, during the course of the Clean Water Act trial, there's one case where Sierra Club brought the case. The judge said the experts weren't qualified as experts, and therefore the club could not prove that the defendants were liable for the pollution. They couldn't prove their case. And then the judge said, well, it lacked merit, and I'm going to award the fees to the defendant under the Clean Water Act. So it took where it was a nonprofit law entity and nonprofit or like kind of land use groups, 1,000 Friends of Florida, some groups like that, challenging a land use plan. And they said this is going to increase density. In the course of the case, the county and the state said, we won't interpret that way, don't worry. And the court said that they lacked standing because they couldn't show they were going to be injured, and then said the case lacked merit and slapped them with sanctions. Went up to, it was in the floor, this was actually sua sponte, The
Rule
Court of
11
Appeals.
sanctions? Rule 11
No.
sanctions, or just?
It's a statute in Florida, or I don't know if it's a rule or statute, that says the court shall award fees for a case that's, bad faith, frivolous, and lacks merit. And the court was hostile to the case by this point and said it lacked merit and slapped him with fees. And it's particularly troublesome. So I know in CLEs you're supposed to give practice pointers. The practice pointer here would be when you file a case and it looks one way, and then along the process of the case, the facts change, or your ability to prove them changes, look again. Because this was a case where it looked different once the county said, oh, don't worry, and the judges bought that. Now, the other courts of appeals in Florida are not buying this approach. The Florida Supreme Court took the case and then just last month said improvidently granted. So we're not going to get clarity. But I think there's a particular risk for chill if you start having fee shifting that's really meant to be a sanction without applying the sanction standards and calling it as such, and sneaking it through another kind of a statute.
Because the sanction standard actually essentially is a frivolousness standard. It is wholly without merit. And what you're saying is a situation may occur where, in fact, there's merit at the beginning, discovery suggests otherwise, midway through it, you realize it's not going to work, and that can't be enabling these kinds of risks, because that would be dramatic. Do process constitutional issues here at all? Anyone? John? Make one up?
No. But could I add something to go back to a point you made earlier, talked about the possibility of it spreading. In Congress, maybe not, but one thing I didn't mention was there are about 14 states that have some form of a loser pay law. Some of them are for early offers. If you get an early offer made and you decline the offer and your judgment is less than the offer, then you have to pay for all costs after the offer was made.
Right, federal rules are like that as well,
Yeah,
right,
so,
offer of judgment.
so there are four, and then some of them are very, very narrow. I think Tennessee did something similar to what Texas did, losing the motion to dismiss, but it maxes the cost out at $10,000. And there are a few other proposals out there. So I think everybody's trying, the state legislatures seem to be trending to try and put some form of loser pays on the books, so it doesn't seem to be going away.
Well, and I think there are some constitutional issues. In both the Florida and the Alaska cases that I mentioned, there are dissents. And the dissents are basically saying at some point you're going to interfere with the right of access to the courts. And under both of those constitutions, there are due process rights that give people access to the courts. And so there are definitely issues there. I like the dissents better in both of those cases. But that will be a curb, I think, to some extent if it goes so far. I mean, one of the things that I think would be great for academics to look into is empirical evidence on how much this does chill litigation and what types. There's a lot of great language. I haven't read the original literature, but it's in different court cases where the judges are saying this does chill litigation. I don't know, I mean, I mentioned it kind of wholesale here. I can't really tell you the clients that have come to us and then didn't bring the cases. You know, it's going to be a difficult kind of study, but I think that would be really useful to have more evidence of the kind of effect that these kinds of provisions have.
You know, one application that occurs to me in the Title VII realm, and this is, I think, more generally true in the class context, which is it's not loser pays, but it's cost shifting. And so, as an example, we're prosecuting a gender discrimination class action against Goldman Sachs, and in the context of that case, Goldman resisted producing discovery to us on the basis that it would cost them $700,000 to pull the data and give us the disk. We disputed that, but in any event, they said it was really expensive. And you know, so there's been an attempt, particularly in the Title VII realm, and in particular in terms of, you know, ESI discovery and, you know, cases that rely on and are built on access to information. You can certainly see that as sort of, you know, an access to justice constitutional dimension to it, because if you were to tell the plaintiffs that they had to pay the cost of producing information, because it's now in this newfangled thing called a computer as opposed to just documents that you could go copy yourself, then, you know, that really does start to look like a loser pay provision, because the only way you would recover that is if you were to win. So it's sort of the default is you lose unless you win. You pay it unless you get it back at the end of the case. And, you know, as that continues to be developed, and we've had this argument now a number of times, particularly, you know, in a Title VII enforcement construct, that becomes the sort of the same sort of economic disincentive that is that we worry about in terms of losers pay as well.
But that's why the conversation has to be set in a broader context, which is putting aside loser pays. what are the changes in civil rights, environmental, public interest litigation in general over the past 20 years, the kinds of things that you're describing, the kinds of things that others have described with respect to limitations on class actions, making this enterprise already an uphill battle. Limitations on attorney's fees. I had been a civil rights lawyer before I became a judge. I was always astonished to hear other judges talk about what they were doing to attorney's fees applications, having no idea what these cases cost, since not a one of them had ever been a civil rights lawyer, and yet they were slashing and burning the catalyst theory, which basically makes problematic, not in every case, but makes problematic attorney's fees if you got the defendant to do what you wanted them to do, but did it without litigation. In other words, makes problematic a non-litigation alternative, and suddenly you may lose access to attorney's fees. So this is all in the context of already difficult civil rights litigation. And then what was interesting is something that you said, Patty, which is it also matters in the context of enforcement mechanisms about injunctive relief and small damages. We care about people having access to the courts in order to get injunctive relief and in order even to pursue small damage claims. And what is it going to do to that? Why don't we open up to questions? If anyone has any questions. Yes, back there. Yes, I can't see you. Oh, hi.
Unfortunately, the panel is all composed of people who are against loser pay, which is unfortunate.
We tried.
Getting the other side.
Right.
So let me make the argument. Because
Clearly, this group has got to be ready for the attack. The idea of shifting the cost to the plaintiff is percolating in too many states, in too many efforts, and the fact of the matter is a lot of Democratic politicians think it's a good idea, and I bet you if you poll business executives, 95% of them would say it's a great idea to make the loser pay. So unless we get a vigorous articulation of the other side, we are not going to be prepared, our community will not be prepared to answer it. And the vigorous articulation I suggest is that England is a very civilized country. It's a democracy. Loser pays in Australia too, New Zealand. Loser pays works fine. And they have developed ideas like insurance, litigation insurance. There are exceptions. I don't know what they are called, but big deal. So they have litigation, and the society operates fine. Why do we need the kind of litigation? First place, would loser plays here discourage litigation? And second place, do we need that kind of litigation? And can you identify for me, obviously you're having a problem identifying cases that under a loser pays regime would never have been brought here and could never have been brought in England. And you got to identify those cases and tell me why they've been good for society.
Someone on the panel?
Well, I could take a whack at that. So, in the Title VII area and the civil rights prosecution area, you look at the Bureau of Labor Statistics on gender and race equality in terms of compensation, in terms of pay, and what you see, you see that women are being paid about 75 cents on the dollar of men, and there are industries that are non-compliant, where women are paid less than that. There are lots of issues that litigation challenges for the better. And, I think through the march of time, and particularly in terms of race segregation, which is another great example, when you look at what the segregated South looked like in 1964 and what it looks like today, a lot of the difference could be attributed to civil rights enforcement. Griggs v. Duke Power.
Private civil rights
Yes,
enforcement.
private, yes, right, private, well, and also the EOC, but I think private litigation as well. That a lot of the change took place as a result of private enforcement of the civil rights statutes.
But so is the next question, okay, done. Do you still need it?
No, I would also say, I'm not sure if any of the asbestos or tobacco cases would have gone forward to the point of where they
Great point.
started to prevail. Because in the beginning, plaintiffs' lawyers, and Steve, you know as well, were losing those cases dramatically. And if they were having to have to pay the tobacco industry and the asbestos defendant companies legal fees and costs, we wouldn't have Barrett and Budd or Waters and Krause or any of those firms. I think they would have gone under that model. So I don't know, and I think those are very valuable cases because they were legitimately hurting people.
Ruben?
Yeah, thank you for teeing up this issue, because we're actually litigating in UK. And I can tell you that for the case we recently brought, it took us 3 years to get the insurance coverage. And in order to get the insurance coverage, we actually had to get a legal opinion that there was an extremely high chance that we would prevail. So the actual transactions costs to get the coverage were just insurmountable for the average plaintiff.
Well, in the sphere in which I work, it is very much part of the calculus on bringing a case, what your liability would be for fees. In a lot of other countries, you wouldn't have the kind of robust public interest litigation. Most countries don't have the kind of citizen enforcement that we have of environmental laws, or the ability to bring cases to hold federal government entities or their government accountable to the law. I mean, that's really a unique and robust feature of our democracy. And in terms of looking for evidence, in Washington State, there is about, I think it was like 15 years ago, the legislature passed a law that said in land use cases decided in the Court of Appeals, the loser will pay the fees if they've lost below. And basically what that's done is dried up the citizen community kind of cases about land use permits because the groups don't want to risk paying the fees. And it's been particularly harmful in evolving the law and interpreting it and bringing any kind of cutting edge case to see what the law will mean and how it should apply. And it really has dried it up. And I mean, I wish somebody would do the study. I know this from being part of the community and the folks that do that litigation, but it would, I have no doubt that an empirical study would show that citizen groups aren't bringing those cases to the Court of Appeals.
Yes.
I wanted to alert everybody to a case I don't think has been mentioned yet and actually will prove to be a good example that makes a difference badly, called Janke versus Lee. It was decided a couple weeks ago by the California Supreme Court. It's a disability rights case. Man in a wheelchair sued a store owner where there was a 4-inch step. He couldn't get the wheelchair over, and they didn't do anything to change the step. But he not only sued under the ADA, American Disabilities Act, he also sued under a new California statute that gave additional rights to people who were disabled to sue. And it turned out he lost on the case because the defendant could prove that the cost of building the ramp and this kind of construct of the building wasn't worth it. It just didn't make sense as a reasonable expenditure given the design of the building, et cetera. But the California statute, the new California statute, had a provision in it that said the prevailing party gets attorney's fees, period. And the California Supreme Court, including the Honorable Goodwin Liu, unanimously endorsed that language as written. No one will ever bring a case under that California statute again, I guarantee you. But the disability rights group that brought that litigation, I should say a private lawyer I think brought it, but the disability rights groups were all alarmed enormously and filing amicus briefs saying, if you do this, nobody will ever use the statute to enforce these additional rights. The California Supreme Court said, well, look, this is what the statute said, and we understand the whole idea of the statute was to make it easier than under the ADA to protect disabilities rights, but then, and so it makes sense why you would then, to deter people from making it easier to win, is say, since we've made it easier to win, if you still bring a case you lose, you pay the other side's fees. But so people need to know the case is out there, but also be a very good sort of, I think one-time proof that this is not the way you actually expand people's rights to bring litigation.
Has anyone studied it? I mean, is there someone, or is this sort of disability rights groups? Okay, all right. Is there any other?
I mean, in response to the argument in favor of loser pays, I mean, it seems the question is, what's the goal? If the goal is just to deter litigation generally, then I suppose it would work. It would. If the goal is to deter frivolous litigation, which I think is the valid goal, not to deter meritorious cases from being brought, I mean, that's the real question, whether it really would have any, greater deterrent effect on frivolous cases. There's an argument that it wouldn't really affect them because, a huge percentage of them are brought by people who don't, I mean, they're not going to care about paying fees either, and they are judgment proof a lot of times. And they're threatened with sanctions as it is and still proceed. I mean, it just seems like what it would clearly deter is people who have cases that are on the line from seeing if they're right or wrong. And that seems, why is that a good public, policy?
It occurs to me, too, I was just in the International Committee meeting in Rome for the ABA, and the UK solicitor talked about how in the UK, and in particular in terms of gender equity or gender fairness issues, that there are lots of very good statutes on the book. There are lots of good rights, but no means to enforce them. And so what happens is they report out on and spend a lot of energy discussing and hand-wringing about the fact that women are being paid less than men, and it's in the context of labor unions, it's in the context of committees and such, but there's no one there who can say, okay, let's sue somebody. That doesn't exist. And so it's essentially reduced to hand-wringing and self-flagellation over things that no one seems to know how to fix.
But Harry, getting back to what you just said about people won't take these cases because they're judgment-proof? Because the individuals who are judgment-proof won't care. What about the lawyers? Where will they get lawyers if there's sort of no pot? I mean, how will a lawyer, what's the calculus with respect to a lawyer if there's going to be a loser pay rule?
Well, I mean, I don't think the lawyer is liable for the attorney's fees.
No, but if there's nothing there.
Well, that's presumably true if you file a frivolous case no matter what, frankly. I mean, obviously there are lawyers out there willing to take these cases and take the chance. I mean, really who it changes the calculus for is the client who suddenly has got, a lot to lose. But if you've got nothing to lose, it won't affect you, I assume.
And then if individual public interest firms back plaintiffs, backing plaintiffs, then they wind up with the concerns that Patty was raising about finding out about who was supporting what and what their affiliations were. Can you talk a little bit more about where that has gone?
Well, that's an anomaly. So, I mean, that's in Alaska in this one case. I don't think that's going to be a trend, I hope. So hopefully the Alaska Supreme Court will clarify that that discovery should not be permitted. I think in terms of environmental practice, and I think a lot of public interest practice, there are nonprofit law firms that exist to provide counsel, and some percent of the fees of the cost of running those groups often comes from fee shifting from the government or from citizen suits. It's not the entirety. My organization's about 10%, but there are smaller groups and there are private lawyers who put out a shingle who do, their business model is basically living on fees that they get from bringing citizen suits. And, that is the kind of case that they do. And I think that's what will dry up if you don't have the fee shifting. And that's really what the whole fee shifting provision and the citizen suit provisions are meant to do, which is have people who are closer to the problems, who care about the resource, being able to act on that and to stand in the shoes of the government and to have the enforcement you wouldn't otherwise have. That's what I think would dry up.
Can I just add to that? It's really interesting just in terms of background because it occurred to me when you were talking about EJA. EJA's been under attack for the last couple of years. But when
EJA, the Equal Access to Justice Act.
Right. When you think about, it's now being attacked by the right, and she quoted two right-wing senators. Very interestingly, it was reauthorized by Ronald Reagan, and it was a darling of the right when it was in its earlier version. And now the ranchers, primarily in Wyoming, Cynthia Loomis, are pushing back very hard against it. It used to be one of their favorite tools when the government was so out of control.
But, so is that the answer? Steve, to your question, is that the answer, that in fact we have a different structure of litigation in the U.S.? We don't have governments that enforce these rights? It is a private attorneys general model?
It's too general to me for me to win the debate with business friends at a dinner party.
Okay, fine.
I mean, there's
You want an elevator pitch?
I need something, I tell you what just came to mind, is you could make a case that people would be smoking around the world if we had loser pays in the United States. That's a good case. Because in fact, if those lawyers had not begun with the beginning suits against the tobacco industry, they wouldn't have led to the class actions and eventually the state
That's a
actions.
great point.
Which ended up ending smoking as a public hazard around the world. So there's a public health revolution that was caused because in this country, the loser doesn't have to pay. That's a good example. We need to come up with more examples like that, I think, to win the argument. And let me ask another question to the panel, slightly shifting the question. Let's talk about contingent fees. Should I be able to shift a contingent fee to the losing party in litigation? I mean, should the plaintiff be able to recover from the defendant a contingent fee? Because I suspect that this is another area where those who are on the right are going to be attacking the progressive legal community to get rid of contingent fees. We've seen cases that have come down in the last month. Everyone now, the business community has an agenda to go prevent the state attorney generals from hiring private lawyers on a contingent fee basis. And so there are going to be efforts to regulate contingent fees, to eliminate them, to eliminate the circumstances under which they can be hired, and certainly to prevent them from being shifted to a defendant under fee-shifting statutes. So what's the group think about that?
Well, I mean, the truth is that the whole push for loser pays in part is a product of the availability of the contingent fee. I mean, I think that the argument is it's just too inexpensive in this country for someone to file a lawsuit because they don't have to pay, a plaintiff's lawyer and they face no risk. So we need to make it more expensive. If they can get around having to pay their lawyers, the one thing we can fix is make it more expensive on them if they lose, because we can't get rid of a contingent fee. But I think that's the problem. If not loser pays, the next thing will be to try to get rid of the contingent fee.
Well, I think that was sort of the locus of what happened in Florida. I mean, once you did shift contingent fees to the loser, to the doctors in medical malpractice cases, then the doctors became converted that that wasn't a really good idea. And unlike loser pay, just straight loser pay proposals in Congress, we do see a restriction on contingency fee proposal in Congress, in every Congress, in multiple places. You mentioned the limitation on hiring private counsel by attorney generals. I mean, I see that amendment maybe 5 or 6 times a year, and it's always brought. We just saw it. Senator Grassley had yet another version of it that he threatened to offer last week, which basically is a transparency model. And transparency said you can hire a lawyer on a contingency fee basis, but you have to tell us why you chose this particular lawyer, what his experience was, how much you're paying him or her, and there was another aspect of it. But it was basically done in a way to try and chill any attorney general from hiring outside counsel. And we saw, I'll just add one more quick nugget. We saw when Jack McConnell, up until a couple of days ago, the only trial lawyer who has actually been confirmed to the federal bench under this administration, when he was during his confirmation process, he was killed, I mean, not literally, but he was really pummeled by Senator Cornyn because he had worked for now Senator Whitehouse on a contingency fee basis when Senator Whitehouse was then the Attorney General. So it's just a line of attack, and I think you're right. That is not going to go away. I think they're going to continue to attack contingency fee agreements in any way that they can.
Yes.
So I have a comment and a question. My comment is, as a former solicitor in England and having worked on foreign non-convenience cases here, where cases can be sent back to England and loser pays, I think that while I agree completely that there is an adequate, the argument is there's an adequate legal system in England. One, contingency fees have just been enacted April 1st of 2013, so we're exporting more than we're importing from England. And there's an fairly activist regulatory system in England, so while I completely applaud our efforts at tackling smoking in the United States, there have been different ways of tackling those problems in England, and I think there's a sophisticated answer to smoking and regulations in England than just we tackled smoking in the US because we have tobacco lawyers and plaintiffs lawyers tackling tobacco. But my question really goes to you, Mr. Bowman, and it's about the legislative history of the SHIELD Act. You alluded to this a little bit before. And it also occurs to me, sort of having listened to our Iqbal and Twombly conversations, and it's this: these inside baseball, possibly rather dry topics of pleading standards or loser pays, these percolate under the radar, and then they emerge, whether they emerge in environmental law or they emerge in pleading standards, and it's too late. And then we're stuck challenging Al Franken or the White House for failing to address pleading standard issues or judges. And I think I would like to see in future ACS conferences, and I'd like you to perhaps talk about this, how we tackle this early. So you're talking to the senator, I've forgotten his name, who's proposing the SHIELD Act, and how we can mobilize to, A, make these somewhat arcane or procedural topics meaningful and express what they are, and also talk to the legislators to sort of make it a more meaningful, accessible topic. I'm sorry, it's a long-winded question.
No, I think that's a great question, John.
That is my day-to-day challenge. Not on that issue, but any of about 20 or so sort of somewhat mundane issues. I guess the fortunate thing about the SHIELD Act is legislative history is relatively brief. It was first introduced last year in the previous Congress. Unfortunately, it has expanded in this Congress. And we do have a pretty robust coalition who opposed it, who are opposing it, for various reasons. I mean, we have people in the technology community who oppose it, people from the legal communities who oppose it. So that bill won't become law. I am fairly comfortable in saying that. And I don't know, in the current makeup of the Congress, given the current majority leader of the Senate, we won't have a loser pays statute enacted in the next 2 years. I can guarantee that. If the Senate were to flip and become Republican-led, then it becomes a little bit less easy to say with certainty that it won't happen. But with the current regime, it may pass the House. They like to do things repeatedly, like repeal the Obamacare standard, I think 37 times now. But it will never pass the Senate in its current form.
Can I just follow up just to say that it is extraordinarily distressing to hear what Arthur described, that Goodwin Liu, who is a champion of the causes that we all share, and I'm sure expresses more articulately than most of us our position, would be part of a unanimous decision endorsing loser pays. And there are other statutes in California that also have loser pays. I think California is very much at the vanguard of loser pays. And we, as a law firm, have considered cases, I work at Leaf Cabreza, where the loser pay statute and the flip in California has been something we've had to consider in our analysis of whether to take a case.
But that seems straight statutory interpretation, though. That seems like it was sort of black and white. I mean,
of course, that's my point. That it just happens under the radar, and then it comes up before our constituency, and we have no choice but to endorse it.
But it's not a judicial issue.
Yeah, it's not a
It wasn't
judicial issue. I mean, it
That's
wasn't.
my point, that in the statute, it comes through, and then a judge has no, it's unavoidable.
Right.
But your broader point, which I think is a really interesting one, is that we've taken the civil rights enforcement, public law enforcement, and enabled the other side to basically cut it apart in pieces. When Newt Gingrich started with the contract, I'll take it from you, to On America, it was a direct assault on the system, and people could understand the connection between this provision and that provision. Now that we don't have sort of a package deal, this is happening in little pieces. And you're quite right that the bench doesn't understand the implication of the pieces. I see this in attorney's fees litigation, which is no one understands that if you begin to nickel-dime the plaintiff's bar, who's already earning less than the defendant's lawyer, it will affect people taking these cases. It becomes sort of an acontextual, formalistic analysis. And so if your point is that we ought to talk about all of this as a package, as an assault on public interest litigation, I quite agree with you. Whether it would work is another question. Ruben.
And the reason I say that is when I was up at the SEC on Dodd-Frank, Mary Shapiro said that we have one examiner for every $12 billion in assets. You could double the SEC's budget, but you're never going to be able to investigate. And going back to the post-Civil War Reconstruction statutes, 1983, 1981, the way we've dealt with this problem, this regulatory problem, is basically to have private attorney generals. Right. That's the way. I mean, the difference between us and China and some of these other countries is we not only have substantive laws, but we have a process. We anticipate how the laws are going to be enforced. And the way we've anticipated it is through, private enforcement where you have injury in fact. We also have the whistleblower statutes. But that's integral to our enforcement process. So when you start gutting the private enforcement mechanisms that are part of the compliance system put into these statutes, you're effectively gutting the regulatory system. And it's not just tobacco. It's Ralph Nader, it's seatbelts, it's everything. And that is really scary. So if you need I think you need to transition the debate, not just about individuals, just about gutting regulation in general.
At a time when you're gutting government enforcement as well. So this is essentially gutting enforcement of this.
Well, and the defense has got to also, of loser pays, or against loser pays, has got to be historic. I mean, we've had it for 300 years, right? And I mean, yeah, England's a civilized country. It absolutely is. But, I mean, the argument is, the U.S. is better. This has been part of our system for a long time. And
well,
that's
so
the
we're
argument.
arguing, American exceptionalism is what we're arguing, yes.
There have been at least two measures on the California ballot involving contingency for limits at 15%, at least one that I can remember, and I think loser pays. In the 1988 insurance wars, one of the 5 or 6 ballot measures was a limit on contingency fees, and it was defeated. There was some great competitive lawyer bashing in the radio advertising, great entertainment, especially when you're driving to work. And the second time, in 1996, there were a couple of measures were intended to be securities litigation reform. One of them, I think, was a loser pays provision, or it was a contingency fee cap, perhaps both. That was defeated as well. And on the statute that was recently interpreted by the California Supreme Court, to me, that's a failure of the legislative process. All you need to do, when this thing was going through any of the committees in the legislature, somebody should have seen that just a flat-out fee shift is not what you typically have in civil rights laws. You have it basically, if the plaintiff only has to pay if it's a frivolous lawsuit. That language had been put in there, this case would never have happened.
Do you want to follow up, because that was your point?
Well, yeah, I have a larger point as well. I mean, for me, I think what's really striking here, what Steve said is right. It's striking first, it's all plaintiffs' lawyers or former plaintiffs' lawyers on the panel. But what are we talking about? I mean, the program is called Winner Stay, Loser Pays Developments and Fee Shifting. I was thinking I was going to learn some good news about fee shifting things because I bring cases all the time where losers pay. That's what we do. We're not against losers pay as a principle. For the civil rights and environmental, we like it. We want more of it. We want multipliers, I mean, let's get real here. The problem is not losers pay. We understand that, in fact, we're in favor of losers pay, and so has Congress been for decades when they're enforcing important rights of people, usually against corporations or the government, the civil rights laws, the environmental laws, the antitrust laws sometimes, different laws. The problem is, so I would, if there have been positive developments, I would love to hear them. That would make me feel better. But I think what's striking here is we're on defense. I mean, there's not even a defense lawyer on the panel, and we're on defense. And from my standpoint, yes, the point you made is, and Nancy, Judge Gertner, that you picked up on was sort of, all right, so how do we anticipate and play defense better before these things? But I also think some thought has to go in, how do we start playing offense? What are the important rights we need to be pushing for loser pay provisions when they violate consumers' rights, other workers' rights, gay rights, whatever it is, and we make it part of the, yes, private attorney generals, and of course, the larger context, for me at least, this is all happening in it, is this is all, the model for all of the work we do is Congress passing litigation, well, except for the contingency fee straight stuff, and of course in England they don't have that at all, but it is, the model is litigation is a powerful tool to enforce rights. And the other big piece here, which ACS, underlines all of this, is it's a part of the attack on litigation itself. It's the attempt to say we need to get rid of litigation. It's just frivolous. It just puts money in lawyers' pockets. It doesn't help anybody. And we have to both play better defense there, but also start playing offense there as well. And I know it's much bigger than this panel, but it seems to me what's underlying a whole lot of what we're talking about.
Can I respond to that very briefly? I think there's fatigue that's set in, at least that's been my experience, particularly in civil rights enforcement. I do a program every year at NYU for the FJC, and there are 50-some-odd judges in the room, and, the conversation is essentially, we're tired of these cases. There are too many of them. They're just not, essentially, they're not federal cases, they're not.
It's like the domestic
Yeah,
relations.
exactly. It's family court. That's exactly right. And so even when you win, you lose. I mean, I have a case, we've successfully sued the state of Connecticut involving applicants for correction officer positions on a gender disparate impact case. It's a hysterical case. The requirement was that applicants for corrections officers had to run 1.5 miles under a certain cut score. Now, I'll ask you, when would a corrections officer ever run anywhere? But it turned out that there was gender impact. We won the case on liability. So we went, and long story short, we put in a fee app and we got 50 cents on the dollar. Now, we'd won every single thing you could win in a case, including motions to dismiss, motion decertify after Dukes, after we had a summary judgment liability grant, which is hysterical. And so, but that's what you see. I mean, that's reality. That's the best case scenario.
Can I just us are the playing defense, and you know this well. I mean, the political climate is such that that's all we got. And unfortunately, the folks who are on the right are long-term investors. I mean, they started putting money into these efforts in the 70s, to try and get to where they are now. And we're not really investing in anything other than short-term defense. Because, I mean, we're playing triage, and forced arbitration, another attack on litigation. You guys do that as well as anybody in the courtroom. We try and do it pretty well in Congress and try and keep it from getting any worse. But, yeah, it's triage, and there doesn't seem to be somebody who is from the progressive community who's looking 10, 20, 30 years down the road. Okay, maybe you.
I think that's what ACS is about.
Well, I mean, I'm talking like really funding in a serious way like the right has done, those kinds of efforts and getting those things in place. I mean, I just don't see an analog on our side. We don't have an ALEC that's out, seeding every state legislature with conservative model bill. So it's just a. Oh, we just invented one. I haven't seen their list of 500 model bills yet. So. Really? Okay. Well, that's interesting.
So I want to respond to a couple of you've been saying that we've got to talk about how do we reframe this? And I would say it shouldn't be just about the lawyers. It shouldn't just be about litigation. I think it's the values that we are promoting in a variety of ways, including obtaining justice in the courts. And it's a place where the evidence is what rules, where there's a neutral arbiter, where it's not just the rhetoric of the day. And I think most people want a fair judiciary, want to have a day in court when they're harmed or when someone they know is harmed. And I think we need to go back to what the principles are, values-based communication. We are a tool for that, but we're not what it's about.
Let me just add to that. So much of the problem in court was lawyers who did not go back to first principles. So the lawyer that was arguing the attorney's fees application was arguing about whether he should get, $400 an hour or $390 an hour. It was not about, let me remind you, Judge, because surely you don't remember, if they ever knew it, the reason for private attorneys general. Going back to first premises was terribly critical and rarely done. And it may be that the general public debate has to go back to first premises, maybe with the asbestos issue, talking about what we accomplished. That's along the lines of what you're saying, but this is a different observation, but the federal courts are focused on case management, dispute resolution, plea bargaining, getting rid of cases, and anything that promotes, that is a disincentive to a case proceeding is valued. But that's a larger discussion, yes.
Is there a basic equality argument to be made? That the issue is, who are our courts really for? Are we going to have a court system where a regular American, maybe impacted by a motor vehicle accident, can afford to go to court? Or are we going to have a court system where the only tables you can play at are the high-stakes tables in the back room?
That's a good point. Yes,
I was going to say,
great point.
we danced around this entire time. The values that we presume, that we profess, and the ones that we want to come back to are not the same values. We are a virtue-professing society. We believe that people should not get what they don't deserve. We believe that people one person should not profit from the injury to another person. And what you get then is the debate about how lawyers on each side are compensated. That's not what I'm talking about. I'm talking about the role of litigation as regulation. And the wonderful comment from the legal lawyer, Bravo, British lawyer, who showed us that in England there are lots of other regulatory variables that you have to introduce if you want to compare countries to countries. We don't actually have a robust regulatory apparatus. We all talk about it on defense, that we have an administrative state. Actually, Europe and other countries have much more of one than we. But here's the thing. When litigation functions as regulation, it does it a little differently. Arguably, it does it better, in greater accord with our values. This is stuff you've just been saying, but I thought I would try to raise it to a conscious level. An individual who was harmed cannot go to the regulatory agency and be heard in anything like the same way. If you go as an individual to a court, you have maybe you have a hearing in the court of public opinion that you wouldn't have in a regulatory, APA apparatus, but you're not an established player. Perhaps you're not a repeat player when you come to court. Maybe your lawyer is. That's another question. But you yourself, as the individual harmed party, have a role in regulation. And of course, it's the regulatory impact of tort and products liability and every other kind of litigation that the corporate interests oppose. And they oppose regulation and litigation for the same reasons. And one last point, and that is that business abhors uncertainty. They abhor it the way nature abhors a vacuum. The forces unchecked of business interests, unchecked by regulation or litigation or what have you, will tend against uncertainty and toward predictability. It doesn't mean that they require zero cost. Cost containment is a force that you'll see in corporate charter worship, if you will, right? Fiduciary, right? But they want predictability. So it's conceivable that tort or litigation in general creates a certain uncertainty. It has a certain sort of crude coefficient of, higher pioneer plaintiff recoveries, uncertain recovery where the case is arguably marginal. 70% of med mal cases that go to verdict are defense verdicts. But is that because the good cases settle because they know better on the defense side, or is that because we poisoned the jury well already? None of these things are known. Litigation is more uncertain. The question is whether we have values that support the right to sue that are more profound and more powerful to the individual in, as I say, the court of public opinion than the corporate interest in predictability that has been much better funded in these public opinion struggles. So I just suggest that we can raise some of these deep values to a conscious level and perhaps win something.
That's a great idea. Mm-hmm. Somebody who hasn't spoken. Yes.
I guess in that context, at least, where employees are filing lawsuits together, there might be the idea that you can invoke a constitutional value of freedom of association. And I think actually the Supreme Court of Canada has maybe made some recent decisions or had a recent decision sort of invoking that right in the context of either employees coming together or unions filing lawsuits.
Can you tell us a little bit more about that?
I actually can't. I haven't.
Okay, okay.
Well, there's Section 7 in the National Labor Relations Act, which protects concerted activity by employees, so it's sort of the same idea.
I think, all the way in the back?
Hi, thank you, Ms. Goldman, for suggesting the call for empirical studies. Throughout as the panel discussion evolved, that was the one thing that jumped into my mind I think would be very useful in this area. So I was curious, what would you suggest how would you design that study, and what variables would you put into it? And also, is there an area of law where there has been the reversal? So some of the best studies I'll draw from clinical trials is that a crossover study where it's situation A to begin with, and then it switches to situation B, and then switch back to situation A. And this way, it's better to control the various changing variables. So do you have any suggestions on designing such a study? And also, how do we quantify some of the values that we care about, so that this study is not just just the number of cases brought, but something that has a lot more meaning?
There is empirical studies on this. There's a professor, Sean Farhang at Berkeley, in their graduate school, is an empiricist, and has looked at the effects of litigation as a change agent. And it turns out that litigation does have effects, and he's done some interesting work there.
I think that's a more complicated question than we can answer, but you can talk to people afterwards. Yes?
I just wanted to comment that I think that going back to Steve Sussman's original question is really important. And one of the things I think we also have to think about is the level of the thinking that goes into a statute like Arthur mentioned. I work in the legislature, and quite frequently the level of analysis is more on the emotional level than on the analytic level. And while studies are really important and logic and whatnot, what becomes very powerful is the emotional sense of, well, somebody's been wrong. That company in Southern Oregon that got hit with the terrible, somebody is suffering that emotional wrong, and being able to turn that around and say, hey, wait a second, it's the flip of too big to jail. Somebody's been wrong. Something's been wrong. We have to think about making sure to be able to make that argument at an emotional as well as an intellectual level, that access to the courts and being able to hold people accountable for wrongs. And this point has been made, but I just think it's really important when a lot of legislators don't always get as deep into the practical implementation and logical consequences.
I think that's a great point. I think that part of it is about not only a legislative strategy, but a public strategy. Again, looking from the perspective of a judge, I can't tell you the numbers of judges who have followed Iqbal and Twombly like lemmings without understanding the implications for the areas that they profess to care about. And so you hear someone who'll say, I had no choice but to dismiss this complaint. Balderdash, right? Of course you have choice. It's a plausibility standard, which could not be more squishy. So part of it is that this all has been disaggregated. These particular kinds of proposals look like they are costless, and then you wind up even with people who are otherwise on our side supporting them or interpreting them. So it is more of an offense strategy. It is going back to your points about the extent to which litigation was regulation, and you can't, like a toothpaste tube, you can't squeeze it on both ends. You can't defund the government and eliminate regulation and attempt to have a country that has any kind of governance. So Ruben, you want to make a last comment? I thought that was a soaring conclusion. It's cool. It's all right. Go on, Ruben.
Nancy's pained that I've made 3 comments in 15 minutes. But, there's this paradox, which is everybody says, the corporate world says, government's lousy, we can do it better, privatize everything. We privatize our prisons, right? We want to privatize our Medicare system. We actually have a backdoor for prescription drugs. We have compendia writers who are privatized. You know, Thomson Reuters tells you what the alternate uses for drugs are. We have private entities who license our schools. The Department of Education stepped aside. We privatized everything, right? So the idea that we've put private enforcement mechanisms into our regulatory system is completely consistent with what our opposition
great
says, right? It's completely consistent.
That's a great point.
That's where they want to draw the line and say, oh no, right? And so parenthetically, irony is last year we gave Northrop Grumman $80 million to do a predictive model on Medicare fraud. They had been a repeat violator of the False Claims Act, defrauded the government multiple times. Only in America could you be a felon and get government business, right? But, you know, we're willing to give them $80 million, right, to help enforce the law, but we're not willing to do it when it comes to, you know, lawyers who actually have the resources to help real people. So that's sort of, I think, the argument.
I think on that note, we conclude. Thank you very much.